Hey everybody, John Skiba here from the Consumer Warrior Thursday night. Hey everybody, thanks for checking in tonight. Hey, I apologize. First of all, out of the shoot, we're running a little bit late tonight. I had somebody drop in the office, and I've got all these papers stacked up all around me, and had to do some actual legal work. And that's because I am a practicing attorney in the state of Arizona, where I help people with bankruptcy and defending against debt collection lawsuits, particularly junk debt buyer lawsuits. We do a ton of those, debt settlement, FDCPA actions, all that kind of stuff. So each and every Thursday night, we come on and we talk about all things debt related, on maybe some strategies on how to deal with them. You know, and actually the people that I just spoke with who came into my office, they brought up something that I was glad to hear, because it's a goal of mine when I'm meeting with people. They came in with this lawsuit and they said, look, we had this built up in our head that we were going, we're all going to go to jail. We always go to the worst case scenario when it comes to these things. And they're like, you're able to lay it out and give us some options and realize, hey, you can deal with this. And that's my whole goal with the channel. That's my whole goal in doing this on Thursday nights, is that, yes, you can deal with this. There are options. And having that knowledge of what those options are and be able to put together a plan, that's all part of giving some of that peace and be able to move forward and not panicking over exactly what's going on. So, the way that we like to do this each and every week is go ahead and put your comments over, if you're on YouTube, in the chat section. I'll put them up here on the screen and we can talk about them. Always, I had somebody giving me a little grief over my disclaimers, but I always say, without disclaimers, what are we? What are we lawyers if we can't disclaim? But my disclaimer is that I am licensed to practice in the state of Arizona. I'm not licensed anywhere else. And so you cannot and should not, but under any circumstances, consider me just yakking away here on YouTube to be legal advice. If you need legal advice, you need to go talk to an attorney, particularly one in your state. If you're in the state of Arizona and you're dealing with debt issues, come talk to me. I offer free consultations. I'll put my information down below, or you can see our website and my phone number scrolling across the bottom of the screen here. All right. One question I wanted to start off with is a question I got from one of the viewers. His name's Anthony. Anthony, and I told Anthony I would deal with this question today, so I want to bring it on up. And, before I talk about Anthony, one thing I do want to let everybody know, at 6 o'clock. So in less than 30 minutes, in 27 minutes, I am going to be on live with a law school friend of mine who has a wonderful YouTube channel that is called Viva Law Vegas. You see what he did there? We went to UNLV Law School. He's still in Las Vegas practicing law. And so we're going to be on his channel doing a live stream tonight at 6 p.m. Arizona time. I believe that's 5 p.m. Pacific time. And so if you want to head on over there, I'll put a link in the chat section as well. But at 6 o'clock, we're going to go live. If you can't get enough of me talking about legal issues, you can go over to his channel at youtube.com/@Viva Law Vegas. I thought that was a pretty creative. Good job, Ben. His name's Ben. We're going to be on that together. So, all right, let's talk about what Anthony had. Anthony is dealing with the junk debt buyer lawsuit, defending himself, being a true consumer warrior, and the junk debt buyer files a motion for summary judgment. Apparently he files a response, and then the court actually set a hearing on it, which to me is always a good sign. If a judge sets oral argument on a junk debt buyer motion for summary judgment, that tells me that the court is considering denying it because there's problems with it. And so he asked me these questions, though. He said he got in there before the judge, and these are some curveballs that the judge threw at him that he wasn't quite sure how to respond to. So the judge said, how is this, meaning the junk debt buyer purchasing an account from an original creditor, how is that any different from a bank selling a mortgage to another bank? And the second question is, why doesn't the letter from the original creditor, apparently there was some type of letter from whoever the original creditor was, why isn't that sufficient proof of the actual sale itself? And Anthony did go on to say, look, part of the problem is, and I think you did a great job here, Anthony, in bringing out that just general letters don't work. First of all, that letter from the original creditor, it's almost always very generic. It very rarely says Anthony's account ending in, whatever numbers was transferred from Synchrony Bank to whoever. And so I think that alone should get you over the summary judgment bump there to be able to get a trial on this thing. But the reason why as well, the fact that even though it's not specific, the other reasons why and how it's different from a mortgage transferring the loan to another bank, it's all similar. And these transactions, they can be legitimate. I'm not saying that they're not all legitimate. I'm just saying the issue is when they get into a court type setting, they've got to be able to have admissible evidence. So there's all these rules of evidence. The rules of evidence. Let me show you my book here. All right. This is the rules of evidence. They're in this book. There's a lot of them. And the reason why there's so many of these rules is because the whole idea is if a creditor brings something to court and the court's going to grant a judgment, and all the powers that a judgment gives to a creditor, they can then garnish your wages, your bank accounts, they can lien your home. The court doesn't want to make that decision unless they know they have the best evidence possible before them. And so the issue that we have with these cases is not that it's much different than when a mortgage sells it to another party, but if the mortgage company were in court or the company they sold it to, they would require someone from the original creditor to come in and testify, yep, that was the original document, yep, and then we transferred it over to the new buyer. In junk debt buyer cases, you don't have that. You get an affidavit at the summary judgment level. You get an affidavit from the junk debt buyer, one of their employees, or sometimes it's just one of their servicers, and it says, yeah, these are all the correct documents. Yeah, here's the amount owed, and yeah, yada, yada, just believe us and let's move on. That's hearsay. So hearsay in the traditional sense is, if someone's on the stand and you say, hey, what did so-and-so tell you? That'll draw an objection to hearsay because the court doesn't want to hear what so-and-so told you. They want to have so-and-so in there to tell the court what happened. Same thing with a document. Documents from the original creditor, say a letter from the original creditor, it's written hearsay. Essentially, it is the junk debt buyer saying, hey, here's what original creditor told us. Just look at this letter. They need to have someone to authenticate that from the original creditor. They need to have someone to be able to go through all the elements of what's called Rule 8036, which is the business records exception to the hearsay rule. They've got to be able to go through all that. And if they can't do that, then the evidence should be excluded. So that's how they're different. So Anthony, I think you did a great job with pointing out the fact that your individual information isn't in there. At the summary judgment stage, the courts are supposed to give you the benefit of the doubt. If there's anything that could go either way, they need to favor you at this stage to be able to get you to a trial type setting. And so I think you did a great job with what you did there. But that's the biggest issue, is that they need somebody to be able to authenticate and lay foundation for these documents, and they don't do it. So that's the biggest problem. So, all right, let me go through some of the questions. And again, you can put them in the chat section on YouTube only. You'll also see my link to some of my tutorials and templates, forms, things like that I put together that can be of help. This is actually going right up here with what we were talking about. I would like to know which Arizona cases I can cite while trying to eliminate evidence for the business records exception. What examples can I cite? It's a good question. It's a super tough question to answer on a live stream. Let me just back up so people kind of understand what we're talking about. We're talking about there's a rule of evidence that says that hearsay is not admissible in court. Okay. You can't ask somebody, hey, what'd your neighbor say? You have to bring the neighbor in. You can't bring in the neighbor's documents. You have to bring in, someone to authenticate or say, yeah, that's the proper document. However, there is a rule that's called the business records exception to the hearsay rule. So we have the hearsay rule, and then we have an exception to the rule. And the exception says, hey, in certain circumstances, business records can be admitted in court and be used against you. However, there's very specific rules. They have to have someone to be able to come in and testify how the document was created, where it was stored, if it was part of the normal course of the business who created it to create that particular kind of document. And they've got to have someone who can testify who has knowledge of these things. that last requirement that they have knowledge, that's the problem they run into. And so if they don't have that knowledge, then the court shouldn't admit it because it's hearsay. So as far as case law you can cite to, case law is what courts decide and has this precedential value as far as that other courts have to follow it. The best place to find case law for non-attorneys is Google Scholar. If you go to Google Scholar and just go, I think it's scholar.google.com. It's free to use. And there's actually a little, I think what are they called? Radio button where you click it because it will say case law. And you can click case law and then you could put a search term in there. And I think you can even break it down by jurisdiction. So you could put it by your state. And that's what you'd want to put: exceptions to business records, exception to the hearsay rule. I will tell you this: Arizona is one of the few states that follows what's called the incorporation doctrine, which is, in my opinion, a bad legal doctrine. And basically what that it says is if the new creditor, if the junk debt buyer has incorporated the documents into their own business records, they can then testify to them as if they were their own documents. This is, in my opinion, is something that the courts, and it wasn't Arizona courts, it's other courts throughout the state, kind of made up just so that creditors can get their documents in. But there's a case called State versus Parker in Arizona that you want to take a look at. If you've watched my channel and seen me argue in the Court of Appeals, in the Arizona Court of Appeals, we argue it at length, the State versus Parker case. That's where I'd recommend maybe you go back and watch that. And actually, you can watch me at 6 o'clock because we are going to talk about that particular argument and some of the arguments that we made in the State versus Parker case. So you may want to head on over to the Viva Law Vegas channel with Ben Bateman and myself, where we're going to be talking about some of that. So, all right, Carla, you did it. It's because I'm running late. Maybe I should start at 5:30 all the time. So, all right. Let's see what we got here. If you can get a discovery request converted to a motion to compel and LBNB doesn't comply, does that open the door for a motion to dismiss in the state of Texas? Again, I'm only licensed in Arizona, so I don't know for sure, but I can tell you some general principles on discovery. So if you send over a written discovery request, and written discovery requests are essentially just written questions, requests for documents, sometimes requests for admissions where you're just kind of yes, no questions, trying to get them to answer it. You send those over and they just ignore you. It's usually not the basis for a motion to dismiss. But what I say, I have in one of my tutorials, I go at length about discovery. And I always say, as a defendant, the question is, do you really want to do a lot of discovery? The reason is because if you're not, the less they have, the better it is for you, because they're the plaintiff, they're the creditor. They have to prove all their elements. You don't have to disprove anything. And so if they don't have the original contract, if they don't have any monthly statements, if they don't have the bill of sale, if they don't have affidavits, yada, 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 if they don't have all of that stuff, then they're in a situation when they get into trial, you can just kind of sit back and at the end of the day say, Judge, there's no evidence here to support it. Back to Anthony's question, if they come in with a bunch of documents that are just generic and say, yeah, there's a pool of accounts sold between Citibank and Midland Credit, but it doesn't say who the person was or who the accounts are, how can the court honestly say that there is enough evidence to support a judgment against you? So it doesn't really open a door usually for a motion to dismiss. You could maybe file a motion for summary judgment, but it for sure makes it a whole lot easier at trial if they have not provided you documents. And it also usually limits what they can just, they can't just show up last minute with a bunch of documentation. So, all right. Charlie says in October, received a summons a complaint for a credit card lawsuit by Citigroup. I responded to the lawsuit, denying all allegations. Nothing since then. Should I do anything or just wait? In Florida. So, like I say, 95% of people don't even respond to the lawsuit. So you're ahead of the game there. So that's awesome that you did that. You may want to go look on the court's website. I don't know the disclosure rules. Like in Arizona, 30 days later, there's the parties have to exchange something called initial disclosures. You might want to go look at that. It's usually rule 26.1. sometimes Rule 16 in different states. Go and see if there's anything else that needs to be exchanged. You might want to call the court and just make sure there's no hearing set and ask them if they can point you to anything specific that it'll show you as far as the next steps. You just want to make sure you don't miss any hearings. I mean, that's going to be the big thing that I would check on there. So, all right. This one says, Karen says, I have a credit card lien that's past the time limit. What can I do to remove it? So if it's something that's on your credit report, you're going to need to go and file a dispute through the credit reporting agencies. Experian, TransUnion, Equifax. You can actually go online and submit something through their online system. The creditor then has 30 days to respond to it. If they don't respond to it, the credit bureaus will just remove it. If it's past the time, if they do respond to it and they want to keep it, then you're going to have a chance to respond to that as well. If it's, so I'm assuming that's what you mean by remove it. So, I'll leave that there. Let's see here. Al, thank you for always showing up each and every week and supporting the channel. I sincerely appreciate that. All right. Let's see what Richard has to say. He says, what happens after you respond to a summons saying that you don't make enough money? Would they keep suing me? Thank you. This is a good question because I get this question quite a bit. As far as, I should say, I see this when people are representing themselves and they submit an answer. Sometimes they'll include information like that saying, hey, I don't have enough funds to be able to pay this. Or sometimes they'll try to submit settlement proposals in their answer. Those things are important, but the proper time is not when you file the answer. All the court wants to know, the way you've got to look at it with the civil court from the court's perspective, is this creditor has filed a lawsuit against you, and in their complaint, they have a bunch of allegations. And they want to know, okay, Richard, do you admit or deny what it is that they're alleging? If you admit everything, then, hey, we don't need a lawsuit, I'll just grant judgment. But if you deny it, then we have a dispute that the judge needs to step in and make a legal ruling on. And so you got to be careful with what you put in there because you don't want to go in and say, well, yeah, I admit that I owe it. Let's just work out a settlement or something like this, like, hey, I don't have enough. So unfortunately, the answer is yes, they likely will continue to pursue it, but it is something you can reach out to the attorney for the other side and work against that and talk to them directly and see if you can work out some kind of settlement. In most jurisdictions, settlement discussions between the parties in civil cases are not admissible in court. It's governed by Rule 408 of the Rule of Evidence in most jurisdiction. And so you feel free to talk to them about it and see exactly what it is that, that maybe there's some type of settlement that could be, be dealt with. So, all right, let's see here. Sorry, I'm scanning through here real quick. Here's a good bankruptcy question. How long does the automatic stay last if I wanted to put a vehicle in bankruptcy but keep it up until the time to give it up? So the automatic stay is the order from the judge in bankruptcy that stops all collections, and it happens automatically. That's why they call it the automatic stay right when we file the case. I mean, we literally file the case electronically, and then there's an automatic order there signed by your judge that tells creditors back off, everything stops. The automatic stay typically lasts the entirety of your case until your discharge is entered. The discharge is entered in a Chapter 7 case about 4 to 5 months later. In a Chapter 13, it can be 3 to 5 years later. So your question, if you're going to surrender a vehicle through your bankruptcy, you can do that. And you can, here's the option that the creditor has in the typical Chapter 7 bankruptcy. The Chapter 7 bankruptcy, like I said, it lasts 4 to 5 months. If you say, hey, I'm going to give this up and surrender it through there, the creditor can either come into your bankruptcy and file a motion with the court. It's called a motion to lift the automatic stay. They want to get rid of it so that they can then come in and pick the car up. That process, at least in Arizona, takes anywhere from 2 to 4 weeks for them to get an order allowing them to do that. What usually happens is they just wait until your case is over and then have you either drop the vehicle off or they come and pick it up. The reason is if they come in and file a motion to lift stay, at least in Arizona, it takes sometimes 4 to 6 weeks to get that order. They have to pay an attorney to come in and do it. And so they end up losing more money. And so some of them will just wait. The important thing I tell people is if you're going to keep the vehicle through bankruptcy, you need to keep it insured. They usually will not even accept payments from you during the bankruptcy, the car lender, but you want to keep it insured just in case anything happens there. So, all right, let's see what Mr. Lowrider has to say. So if we come up on a settlement amount with the junk debt buyer in court, is there a letter or receipt, or should I ask for after paying them off? You should always ask for something in writing if the settlement is reached. If they agree to it, like saying, okay, we're going to do X amount, you're going to pay this much lump sum. Most creditor law firms should be willing to give you, we call them settled in full letters, a letter saying, hey, if you pay this amount, this debt will be considered settled in full. You want to get that before you pay anything. And then depending on where stage the lawsuit's in, you're going to want them to make sure they get it dismissed and dismissed with prejudice. If you filed an answer in most jurisdictions, you're going to have to sign off on that. It's going to be a stipulated motion to dismiss. Have it be dismissed with prejudice, meaning it can never be filed again. So let's see here. 5.0 says, after winning my fifth, taking the junk debt buyer arbitration, now the law firm wants me to sign a confidentialities arrangement for not using my method, for not using my methods, your opinion on what to do. That's interesting. I can tell you what, an attorney one time that I was when I was younger, I was at what's called a continuing legal education, told me. He says, he goes, when creditors ask for me to sign confidentiality clauses, I say no. But if it's something that they really want, they're going to have to buy it. That my silence is not cheap. And so it's negotiated. So I wouldn't just agree to that. I mean, there's no reason why you should put yourself in any kind of situation where you feel like you're worried you can't say anything online or somewhere. If they want to pay you a bunch of money to do it, I guess you could do that. But I wouldn't just agree to it. So that's my own opinion on it. So I don't know all the facts of the situation, but I wouldn't agree to do that. They just don't want the word getting out that they probably drop these things when you push them into arbitration. So, all right, let's see what Tiffany has to say. I have a court date coming. I just want to settle by making payments $50 a month. Do I have to show up in court first or send the letter before the court date? So so the thing is, with most courts do not get involved with settlement. They don't negotiate that. I mean, sometimes they'll do mediations, but usually they're not going to help negotiate the settlement on this. And so you wouldn't want to send that to the court, but you need to reach out to the other attorney and ask them if they're willing to agree to that type of settlement. Now, I can tell you, depending on the total amount that's owed, they may be, $50 a month, they may not be willing to do unless you entered into what's called a stipulated judgment, which is you stipulate to judgment, but they agree not to do any collections on it as long as you're making that amount per month. So that would be my recommendation there. So see here, it says, I just mailed off my request for arbitration with the clause for my original creditor being sued by Cavalry. Do judges deny those often? Sometimes they do. What I'm seeing more and more is they stay the litigation to stop that and say, hey, you have 60 days to pursue it. And then one of the parties has to go out and initiate it. If they deny it, that's something I've even appealed that. I have filed motion to reconsider because you're just trying to enforce the agreement of the creditor. You're not making something up. This is their agreement. So let's do one more, and then I'm going to have to jump over to our live stream here. Homer says, I'm being sued by LBNB for $1,600. I'm a senior who's considered judgment proof. I would still like to fight it as I do not want a judgment hanging over my head. Any advice on fighting this? I would recommend maybe check out some of my tutorials that I have linked up here at the top of YouTube. Check them out and see if those would be of help. And yeah, if the debt's changed hands 3 or 4 times, the more it's changed hands, the better, because usually the worse the evidence is, the more people they need to be able to establish their chain of title. And so that's a better case to fight. So I would recommend doing that. I have a whole set of tutorials called Defending a Debt Collection Lawsuit from Beginning to End. Check that up at the top there. So, all right, I have to run over to our live stream now. So I apologize I couldn't get to all the questions tonight. Again, go over to youtube.com/@Viva Las Vegas. I don't know if he takes questions. I know it's a live stream, so you can put things in the chat, bring him over there. He's an old bankruptcy attorney too, so maybe you'll get somebody else's view. And if you're from Las Vegas or in Nevada, even better, because you'll have a Nevada licensed attorney to help you out. So head on over there. We're going to start up here in 5 minutes, and we will take it from there. Thanks for watching in today.